very serious case can really make the difference of us finding someone and not finding someone when they do not come to court.
Thank you. I really appreciate it. Thanks for walking us through the process.
Thank you.
Very helpful. Let's hear now from Nina Salarno with Crime Victims United.
Thank you. Thank you, Commissioner, for asking me to be here. One thing, and the rest here, one thing that I found interesting listening to everybody speak, with the exception of two people, there was only a cursory mention of the victim. And I believe the victim has the biggest stakeholder in any reform to our bail system for the following reasons. One, before the commissioner or anybody attempts to reform the system, we need transparency, which means we need a true number, because that 62% number is not correct. Because what it does not only take into account is not only the people that are held on parole or probation holds or ICE holds, it's also not taking into account that Prop 47 and Proposition 51 have lowered the number of beds available to hold people in our county jail, because now they're being taken up by people who normally should have gone to state prison prior to Prop 47, and they are now taking longer sentences in our county jails. So really, that number needs to be commissioned in a study so there is a true and accurate number for the people, because the people you're jeopardizing by having a false number are the people of your community that want public safety. Also now looking at the victim's rights, which is where this comes into play heavily in any pretrial reform. Marcy's rights, which was codified into the Constitution in 2008 overwhelmingly by the people of the state of California, not only said that the victim had a place at bail hearings, it also said that the victim has a right to due process and a speedy trial. And that is something that is sorely missed in the state of California and sorely missed by any reform to the bail system. For example, in Sacramento County alone, there are 54,598 outstanding warrants for failures to appear in court. 54,385 of them are due to people who either have a pretrial release or are on OR release. That is a large number. That means that those 54,000 victims do not get their day in court. They do not get their due process. And as a victim of a crime, as a former prosecutor, and as an advocate for crime victims, our day in court is just as important, not more important, but just as important as the defendant. And when you overhaul the system and don't have accountability to have people brought to court, then the entire system loses, financially, emotionally, and the toll it takes on the victim as well. So any pretrial, any type of reform, any pretrial release must consider that, must consider the accountability to have the defendant in court. And that is mandated by the Constitution and the rights of victims. Also, what is mandated is that the direct safety of the victim be considered. That does not happen in the current pretrial release system. No offense to Santa Clara County, but I looked at their instrument. There's not even a question of who the victim is. Does the defendant live with the victim? It does not look at what are the prior crimes. It simply asks, what are your prior convictions? There is a huge difference in our system because we all know our system works because of plea bargaining. Thus, somebody could have committed a felony domestic violence prior, yet it was pled down to a misdemeanor battery conviction. And the only thing that's going to show on that pretrial is that it's a misdemeanor battery conviction, not that it was an underlying domestic violence, not that it was initially charged as a felony. The true facts of the crime on a risk assessment are grossly inaccurate. And probably the best example of that, because we have static risk assessments, I'm sure you're all familiar with Philip Garrido, who kidnapped J.C. Dugard and held her captive for 19 plus years. He scored low risk on a risk assessment because of the static nature of the questions. And that is a flaw. And I don't mean that offensive to any county, but it does not take in the consideration of the direct harm to the victim, which is the net effect on public safety. With that said, if you're going to look at any type also of that, we have to look at the cost. We've all heard about the costs to the counties or the cost to the system of holding people incarcerated. Well, what about the cost to the victim? Because if you are going to do pretrial release reforms, there are going to be fees and fines assessed to pay back ultimately what the county has expended for those. There is nothing in that system then that says the victim gets paid first for restitution. which is constitutionally mandated, but is again missed in any reform. So you're going to be adding fees and fines to people that are allegedly can't even pay to bail, yet then we're going to ask them to pay back the county before we pay back the victim. And the Victim Restitution Fund is having a hard enough time covering to make the victim whole. So again, there is this net effect of any type of reform. I'm not saying that some reforms are not necessary. It sounds like as if bail agents need more regulation. But to say that the entire bail system is inadequate or unfair or unconstitutional, I believe is wrong. I believe that you are not considering the other constitutional rights of the other people in this system, because we're only looking at one side, and there are two sides to the scale of justice. Bail for many victims ensures their day in court, and it ensures justice. So I believe when you look at any type of reform, you asked the question at the beginning, Commissioner, that you were most interested in this cost versus holding people in jail or holding them if they can't bail. I believe the true question needs to be, what is the cost versus public safety? What is the cost versus the balance in the system? And what is the cost ultimately to the people who are the victims of the crime, who should come first in many ways? And their interest should be as equal as anybody that is also held in the county jail. So again, in wrapping it up, I would urge you to be completely transparent. I think one of the main things that needs to be done is a statewide study needs to be commissioned as to what people are actually being held on. Because I would guarantee, and as a former prosecutor, I know very well, and given the current system, given the fact that the recent Proposition 51 passage allows for more credits, that you're going to find it's a very small population that is held because they can't make bail. Most people that are sitting in our county jails are either serving what should have been state prison sentences are now serving them in county. They're there under the advice of their public defender because you get 2-for-1 credit or 3-for-1 if you're sitting there going prior to your sentencing, or they're there for holds. They're not going to be there because they can't make bail. And so I would urge the number one step, and I think you do owe this to the people and to the victims, is to have a true and accurate study with the right numbers.